Hello and welcome everyone. I hope you're well. We're just waiting for the participants to join the webinar. So as we wait for everyone to join, I hope you get familiarised yourselves with the control settings. This afternoon, Rosen QC is going to be chairing this session. We're looking forward to everyone's contributions, and Mo will say more about that now. If you do at any point want to ask a question, please do use the Q&A feature that is there, or raise your hand, and it will be my job to moderate the session. So and keep an eye and bring you in. So as we're just waiting for another minute, just as attendees log in, then we'll get started, and Murray will take over and take the floor. I hope wherever you are anyway, whatever time of day it is in the world, I hope you're having a great day. I hope the sun's out for you and you're comfortable in your home setup, or if you're back at work. Right, other than that, right, I think most people are in. Murray, I'm going to hand over to you to take the floor.
Okay, thank you, Sean, and welcome everyone. This webinar is all about consultation, and as Sean's already said, we would welcome questions, points, responses. But if you could keep those contributions to a maximum of a minute, hopefully we'll be able to use our time as well as we can. Dispute resolution has not always thrived in times of plague. History is full of examples of rulers and their courts and their judges all leaving their posts and fleeing the city. In Moscow in 1771, there were riots. One of the archbishops was murdered for trying to stop people congregating. Some cities have done well as a result of the aftermath, but many have taken years to resume normal service. For us in sports dispute resolution, the technology is in one sense a godsend, and a lot of us are working very hard to try and keep going with dispute resolution. But for participants, whether they are the disputants, the athletes and associations, their lawyers, the experts, the interpreters, the arbitrators, and the institutions, there are real stresses. Some of those result from the process as we have known it for many years. Some of them are more specific to what's going on now with COVID and the effect it's having. Social isolation cannot be underestimated. And for people who are in disputes without their usual support, having to deal with timetables and having to deal with meetings, proofing of witnesses, formulation of their legal cases, and all the other difficult pressurized steps that we have been treated quite rigidly in the past by many institutions. It is a very difficult time. And so we've come together as an ad hoc working group with three essential methodologies that we're going to try and use to sports dispute resolution in these difficult times. First, we want to know about experiences and we want to hear anecdotes. Secondly, we want to know what guidelines are being instituted, are being published by various bodies, sports and arbitral institutions and associations and others around the world. And third, we want to examine all this information and see whether or not some common guidelines can emerge. Maybe they'll be very basic, maybe there'll be very wide variations amongst different countries, different sports. But we want to see how far we can get with that. And the more people who can contribute to this, the better it will work. Many thanks to Sean for hosting. We distributed about a week ago is really the product of just a handful of us getting together and eating out a few questions and a few answers. It didn't have any structure. It didn't seek to draw any lessons or give any generalized advice. Today, we're going to try and provide a bit more of a structure. We've got 7 speakers who will be talking for a maximum of 5 minutes each. And between each of those 7 talks, we'll have about 5 minutes, maybe slightly longer, for all our participants to make the points that they want to make, to ask the questions that they think are important. The whole session is being recorded. Everything will be analysed, and we'll be producing reports in due course to circulate amongst you. I'll say something right at the end about what we hope our next steps could be. Please publicise this. Please get more people involved. Our 7 speakers are in this order: Graham McPherson QC, Nick DeMarco QC, Kendra Potts, then Roberto Baracci from Brazil, and Desina Mavramati from Switzerland, and then Stephen Flynn and Chris Stoner QC. As and when points occur to you that you want to make, you can either write them into the chat box, or you can put up your hand, and the eagle-eyed, always focused Sean hopefully will pick up your indication and will try and deal with the requests that come in. We may not be able to deal with everyone. We'll do our very best. So with no more ado, let's start with Graham McPherson. The idea is that we will be going in stages through the dispute resolution process. So we will get to points about the hearing in the second half of the session. We're aiming to finish by about 4:20 p.m. BST. That will be different times around the world. Sean, anything from you before Graham McPherson gives us his few minutes?
No, I think just hand over to Graham. I shall unmute your microphone, or you can do it, and then we'll get going.
Thank you, Sean. Thank you, Murray. I'm Graham McPherson QC. I'm a barrister at 4 New Square in London, and I practice in the field of sports law. That practice comprises, in part, advocacy and representation of parties, in other part, sitting as arbitrator and judicial panel member across a variety of sports. And as away from the law, I retain an interest in professional sport, in that I train racehorses as well. As Murray indicated, we are going to take things in chronological order through the proceedings. So I'm actually kicking off with pre-proceedings, and I'm going to concentrate on an aspect that is ancillary to the proceedings that will often precede it altogether, and that is ADR. I'm going to look at 2 aspects. Firstly, the use of ADR generally as a tool for resolving sports disputes. And secondly, I'm then going to look at the challenges that ADR poses while we all work remotely in these COVID times. My personal view is that ADR is a grossly underused resource in sports disputes. I'd be interested to hear the views of others as we proceed through this webinar. Of course, experiences will vary from jurisdiction to jurisdiction, but I wouldn't expect too many to dissent from the proposition that to attempt some form of ADR now is the norm in commercial litigation or arbitration, but equally that is simply not the case in sports disputes. There is a deeply held perception by many working in the field that ADR, in particular mediation, just doesn't work as well in sports disputes as it does in other fields. Now, we can debate at great length as to why that might be, and that's going to take up far longer than my 5 minutes, but I'm going to suggest 2 reasons. Firstly, I think ADR requires participants to have a willingness to approach the process to compromise, and that doesn't always sit easily with participants in sport whose very existence requires them to be single-minded and uncompromising in their day-to-day lives. Secondly, it's become rather a self-fulfilling prophecy, it seems to me. The perception is sports disputes do not work well in an ADR context, therefore people don't try them, and therefore we don't move forward. But does ADR in fact work in sports disputes? I'm not going to pretend it works in every sort of case. Disciplinary cases, or certainly certain types of disciplinary cases, are not amenable to ADR, and likewise some disputes where there really can only be a binary outcome are often not amenable. But in the majority of other cases, I'd say the vast majority of other cases, ADR does work just as well in a sports dispute as it does in any other form. And for support in that regard, speak to people who have tried it, and anecdotal evidence suggests it works just as well. But the statistics that are emerging, in particular, the Canadian Sports Dispute Resolution Centre has been keeping statistics over the last few years, and their success rate where the parties voluntarily undertake ADR is extraordinary. And actually, even where the parties are forced into ADR, there is still a very significant degree of success. So it can work, it does work, but does it have any advantages over a more formal process such as arbitration or litigation? The answer to that certainly is, I think, yes. I'll give you four. Start with two very practical ones: speed and cost. Just compare the speed with which ADR can be arranged and attempted and the cost of that process with the speed and cost of a typical full-blown arbitral process. Two more esoteric benefits, though. If ADR is attempted quickly enough, particularly in the current times, entrenched positions really can be avoided. And in situations where either a commercial or ongoing relationship is desirable or even essential, that can be invaluable. The second slightly more esoteric benefit, though, is the flexibility that it offers. A good mediator can assist the parties to be incredibly creative in resolving their disputes, and that's just not a route that's open to an arbitrator or a panel. So if it can work and it's got advantages, how can we increase its use? The reality is, until attitudes change, it's not going to happen. There needs to be a degree of forcing. Cost sanctions for those that decline arbitration would be one route. Making ADR compulsory would be another, albeit an unpopular one. Finally, 30 seconds on the challenges of remote mediations. Again, the principal one is going to be perception. How can it possibly work? Well, I think the answer to that is by making it as true to life, as close to a face-to-face mediation as possible. Virtual breakout rooms, virtual remote sessions, and that in turn requires good tech, and others are going to talk about that when we come to the proceedings themselves, and a good mediator. A good mediator will keep the parties focused. It's hard work doing anything online. Mediation online is no exception, but a good mediator will keep the focus, will keep fatigue and tension out of the process. It can work, it does work, and it will work better.
Great, just on time, 10 seconds over. I had that, so thank you very much, Graham.
Sorry about that.
Yep. So Massimo Cottrell, he's in. I know he's got to shoot off at 20 past. We've already had a comment from Jeff Benz that you may need to respond to, one of your colleagues at 4 New Square in the chat. But if it's okay, I'm not sure if there's any questions. Haven't seen any yet. Obviously, we'll have plenty of time for questions throughout the session. I'm just going to find Massimo on here and allow you to talk. So Massimo, can you hear us?
Yes, I can.
Excellent. Would you like your video on? Or
yeah, okay, fine.
Yeah, you should be able to put your video on, I believe, I hope.
Yeah. Well, yeah. I can see you at least.
So,
all right.
Yes. Over to you.
I nothing to say about mediation in this sense. I don't want to add anything to that. I just want to mention my experience so far in sports arbitration has been with parties that are very reluctant to go on to mediation proceedings. That's my experience, at least. Sometimes I had some successful attempts myself with my colleagues on the arbitral tribunal to induce a settlement, but to defer to mediation, I've never succeeded, although I tried even hard many times. So that's all I have to say, just a personal experience. In many, many years, I must say, I started with sports arbitration in 1995. So, you know, it's a bit of time.
Thank you very much for that contribution. I've known Murray. So Graham and Murray, we'll go to Graham and then Murray. You can both unmute your mic so I can do it for you if you'd like. Right, Graham, did you want to take that then, Murray?
Yeah, I was just going to take it very quickly in response to that. I completely agree with what Massimo says. There is a huge reluctance on the part of people to attempt it. And the default position is, it's not going to work. Why should we bother? We have an entrenched position. That was precisely the approach that was almost universal in commercial litigation 20 years ago, when mediation first became fashionable in the UK after it came over from America. And it took a huge amount of time and effort to break that perception. And it has broken, and it is now extremely successful. I'm not in any way suggesting that breaking the perception, changing attitude is going to be easy. But if the change in attitude can happen, the results will follow.
Great. Murray, did you want to contribute something before we come on to Nick? Just for time, we need to keep things moving. So Murray, I'll unmute your mic for you.
Is that okay? Can you hear
Yes.
me? Yeah, sorry. Mediation in sports disputes doesn't really involve proceedings, separate proceedings, and it doesn't to the mediation as this. You can mediate at any stage, and proceedings can be continuing in the meantime, or proceedings can start in the meantime. The essential ingredient is that you have a neutral, a trusted neutral, who has to be very experienced in this type of dispute, and who both parties will be able to confide in and will be able to tell exactly what it is that's going on from their point of view. And the success rate is remarkable. The cost in terms of additional fees or expenses is usually minimal. One of the big issues, though, is who do you get to do it? And in some systems, they expect members of an arbitral tribunal or a panel to carry out that sort of role. But conventionally, that's impossible, because the mediator is being told things confidentially on each side that they would not want an arbitration tribunal to know. So one idea that I think is gaining traction is that where you have stand panels for different sports, different associations, you can have someone off that panel, off that list, who the parties can agree on, and who will be expert and cheap and will not be able to communicate anything with the tribunal. And it adds nothing in terms of time and virtually nothing in terms of expense.
Okay, thank you for that, Murray. Sean Jones has put a helpful comment in saying Edwin Glasgow's are particularly brilliant on this. I know that he was contributing, so it may be that we can come to him further on mediation. Nick, over to you next. By the way, just a distinction for those people who are listening. If you want to ask a question, please put your question in the question part as opposed to the chat, because otherwise it will get unworkable in terms of just keep strolling. So Nick, over to you.
Thank you. Good afternoon, everyone. I'm Nick DeMarco, QC from Blackstone Chambers. I'm a sports lawyer, mostly an advocate, but sometimes an arbitrator, although I spend about 95% of my time in sports arbitrations of some kind. Almost forgotten what the inside of a real courtroom looks like. Thank you for joining us on what is, in Hackney at least, a really hot sunny day. So thank you all who've joined us, and I'm very honoured to be here amongst such august experts in the field to try and add some thoughts and ideas and listen to yours. I really wanted to talk about three things quickly in my 5 minutes. The need for interim relief, which is something I'm quite focused on, fast track procedures, and then just a question of harmonisation more generally. Interim relief, first of all. For any system of alternative dispute resolution to genuinely offer an alternative to court procedures, you often will need to have some procedure by which interim relief can be granted. And I think that's particularly the case in sport, because sport by its nature it is a field of activity which often requires speedy decisions to be made. In particular, as a result of the COVID-19 crisis that we're having, it seems to me that issues arising that will often require interim relief remedies as opposed to going through the normal slower process are likely to arise. I mean, obvious examples are players not being paid on time or at all, or people ripping up contracts or walking out of contracts, where to wait for the full normal procedures under a sports governing body's rules to get onto a hearing would simply not provide the parties with a sufficient or appropriate remedy. So I think we need to use this time to look at whether or not there are interim procedures in your sports governing body in the area you practice in. If there are not, whether you should try and fashion some. If there are some, try and understand them, because people often don't look at them and see how they work. CAS, obviously, well, it's well known, has a provisional measures procedure. Personally, I think that the Football Association, the English FA's Rule K8 procedure is a very effective and sensible one, and perhaps could be a good standard for others to look at. But basically, I think what you need to look at is some kind of procedure by which the parties can get on before a single arbitrator. There's no point having a panel for this sort of thing. A single arbitrator who has to be appointed by a neutral identified body, such as Sport Resolutions, who do it for the FA, within a few days, and who has the power and the jurisdiction to grant interim relief. And obviously that can then be backed up in the court. And if your governing body, if your sport doesn't have those types of procedures in place already, then as well as looking at whether you should perhaps now try and bring them in, I think what you need to look at is making sure the parties can have the alternative of going to court to get it. And you may or may not like that, because you may or may not want those issues ventilated in court, but unless you offer an alternative, they've got to be able to go somewhere to get the relief they need. So that was interim relief. More quickly, someone else raised with me the need for fast track procedures generally. And I think this is important, because you may have a small claim, a commercial claim in sport, which is perhaps less than £20,000 or £30,000. And in a lot of sports arbitrations, you can quite quickly run up costs, at least jointly between the parties, of that kind of amount. Is it worth then us looking at some kind of cross-sport, not small claims, but fast-track procedure, whereby a cap on the amount of compensation can be appropriate? It can be single arbitrator, it can be appointed relatively quickly, there can be cost capping and so on, and the parties can choose whether or not to use that procedure. So I think that's something to look at. Again, paper hearings only maybe for some of those faster track claims. And then the final point that kind of arises out of this and out of all we're speaking about today is about the approach we should be taking in this discussion to the question of harmonization more generally. And I think it's extremely useful for us to share these ideas and to work out if we can have some kind of harmonized approach. But it's also important to—
Sorry, Nick, to interrupt you. We're coming to your time's up, but I'll allow you to continue, obviously, to finish, but just a heads up.
Yeah, okay, thank you. It's also very important to recognise the different needs of different sports. There's a difference between a multi-million-pound arbitration in a sport and a regulatory dispute worth not a lot of money, but a lot for the people involved. And it's impossible to impose a one-size-fits-all straitjacket in terms of guidelines. Nevertheless, if we can have some basic procedural guidelines on how to do things like video hearings, which I think Steve's going to touch on later, those can be very helpful.
Thank you very much, Nick. So we have a question from, well, one, Despina, did you want to say something, or shall I take a question from the floor? Just because I know that I think you may have a view on this.
No, it was, thank you. So it was just a remark on what Nick was saying. So that it largely depends, the interim measures depend on the procedural rules in place. So for example, the CAS proceedings provide that it's only possible to file a request for interim relief together with a claim. So you cannot just file an interim relief before the actual claim. That was just a
Thank
short
you.
comment.
Yes. Thank you.
Yes,
that's
the same in the Rule K procedure, and generally it's the same in court, except there is a way of getting around that in court. So perhaps we need to look at that. Sean, if I may, John Merzad's
that's exactly. I was going to
the fact that we as sports lawyers know that August is often our busiest period. There's lots going on in football, for example, but the courts are generally shut, and it's often very difficult to get hold of arbitrators and so on. It's a good example, and perhaps what we are now learning in terms of the ability to get up quick hearings by video across different continents even is perhaps a good lesson for us. Even if you're in your villa in Italy in the middle of August, you can deal with an emergency application for an interim injunction in the transfer window.
Great, thank you. If you do want to, so thanks for the question, John. If you're a reminder, if you want to ask a live question, if you want you to have the opportunity to speak, then just raise your hand. If you just raise your hand, I can come to you and say, you know, or in your question, you can say you would like to speak. But thanks for the question, John. I don't think there's any other questions unless there's any other contributions. If not, we'll move on to the next speaker, which I believe is, he says with like a trillion different windows open, Kendra.
Thanks,
Over
Sean.
to you.
Thanks. I'm Kendra Potts, another sports law barrister for New Square. And you've heard a bit already about pre-action and the early stages of litigation, and you're going to go on to hear about the later stages and how to prepare for a hearing in obviously these difficult times. But what I just want to say is, of course, before parties dive headlong into a hearing, the really, really important question, of course, is should the case proceed to a hearing at this stage? Now, of course, the balance here is this. Parties often want to resolve disputes quickly, and they don't want them hanging over them. Not all, some want to delay, but often they want to resolve disputes quickly. And we're also being told that despite the difficult times, business should continue as usual where it can. And of course, the legal profession is taking a lot of steps to do that with virtual hearings and all of those sorts of things. But the ultimate goal of litigation isn't just reaching an outcome, of course, it is reaching an outcome after a fair process and after due process requirements have been met. And so the question in every case, which must be given really careful consideration, is not just do we progress this, because of course we must, but should we? Can we actually do justice to the case in each case? And I think that needs to be looked at really in two ways. One is the nature of the case itself. And then the second part of that, of course, are things like access and availability. So as to the first of those, the nature of the case, the sorts of factors that would be looked at are things like, is it a case in which fraud is being alleged? Is witness evidence and cross-examination going to be critical? And of course we can do that virtually, but is it important in actual fact that the court can see a witness? And we've all heard comments from judges about how they find it helpful to see witnesses there in person and the importance of a witness being there in a courtroom. I think there are balancing considerations. Of course, cross-examination can work well in virtual forms because actually there's nowhere to hide on camera, but at the same time, it lacks the formality, of course, of a courtroom. Is it a case that not just because there's fraud, but is it just a case that is heavy on witness evidence? Are there experts, and how are you going to make that work? If you have multiple parties, again, that makes it more complicated again, and how are you going to make that work? Or for example, the volume of documents. So you will hear later about electronic bundles, and that's great, of course that's great, but how is that going to work? And leading on then really to access and availability, how will that work for the parties in this case? We've heard stories, of course, from the courts about how we can go ahead with this and all you really need is to make sure that every party has 5 screens. Not many people are sitting at home with 5 screens available. So actually, if it's a case that's heavy on documentation, is it actually workable? And that does tie into, as I say, access and availability generally. And that is both in terms of the parties and, of course, the advocates. And again, we've heard the sorts of horror stories that have come out of initially in this pandemic, of course, wanting, of course, to move forward. But perhaps some members of the profession who are slightly older don't have young children at home, who have forgotten how difficult it might be when you are sitting at home with children, and of course at the moment no childcare, or you might have care responsibilities for other people, and then there are of course things like illness. The other side of that, of course, is younger members of the profession who might be flat sharing. There might be 4 people in a flat, and it's actually very difficult for them to sit there and actually conduct a whole hearing. So a lot of those considerations need to be taken into account. And I think that's where I think there has been a lot of progress on that already, as awareness has developed. You don't have the people sitting in their ivory towers in their big houses with sort of 5 floors saying, actually, this is very easy for me, why can't you do it? And that then all has to be taken into account, of course. If it's going to be difficult for parties, of course, then applications need to be made for adjournments. And these need to be considered carefully both by the parties and, of course, by tribunals, because the evidence needs to be put in. It obviously cannot be right that a party can just say, well, I would like an extension, because, of course, some parties are trying to delay inappropriately, and that of course can't be permitted. So enough of an explanation needs to be given. But again, of course, we've heard these stories of parties being asked to put in evidence as to their childcare, which of course is totally inappropriate and has now been recognised as being inappropriate. If a party says they can't attend because of childcare issues, then that's the end of it. But it's those sorts of considerations. Enough evidence needs to be put in without obviously crossing the line. And those are the sorts of things that, of course, parties need to be aware of, and then tribunals when they look at the applications that come in. And really, where I think that just leaves us is you're going to hear now about some of the measures that can be put in place to move hearings forward in a productive way. But before we do that, first of all, consider whether it's possible. But then throughout the whole process is, I think, a need for flexibility. That is the greatest thing. Of course, cooperation, but flexibility from parties and from tribunals, not just to try to move cases forward, but critically to make sure that it is done in a fair way, meeting due process requirements.
Thank you. I had my timer just going off just as you finished. Excellent timekeeping. So thank you for that. This might be a great opportunity. I know that Jeff Benz is itching to contribute. As for those of you that know him will know he's always got something to say. But it would be interesting to hear his perspective. I think he's made some great points on the chat that would come out. But before I do that, Nicola McCulloch, who's a forensic psychologist, some of the points that Kendra made, maybe it'd be worthwhile bringing her in, although she just seems to have dropped off at the moment. I was going to bring her in. So in that case, I'll get Jeff Benz, and if she appears back, we'll bring her back in. Jeff, would you like to contribute?
Oh, I had to self-unmute there. All right. So please don't put me on video, because the visage is not anything worth looking at. So I just wanted to add a few things to this. I've been banging through this since we had our lockdown in the US, starting right around the time the UK did. And I've had, in the last week alone, I've had about 6 of these preliminary hearings with parties where there are objections raised, usually by the respondent, to keeping the current hearing date and adapting new technology. And I've been successful in convincing, cajoling, and in one case, actually at the end, finally ordering it by answering some of their questions. So the witness question always comes up, witness credibility. How are you going to be able to evaluate that? That always comes up. If someone's going to talk to that, I'll hold my powder on that. But there's been some silly responses of international institutions. My favorite silly one was the HKIAC just published a revised set of guidelines that says that everyone should have an invigilator in the room with them. So imagine somebody testifying from their home office. I had to look up what an invigilator was. Having a third party sitting in the room with them, verifying no one else was in the room with them. And then it also insists that they have a 360-degree camera. Like, that's silliness, right? No one's gonna be able to do that. But there are ways to guarantee that witnesses testify and they're not coached. And part of it comes from just watching them testify in a screen that focuses purely on their face and their image and everything else. But once you work with the parties through some of these things, assuming the institution has the right set of rules, and for example, the ICC has a requirement cases be dealt with expeditiously by the panel, and the ICDR and the AAA and JAMS have rules that say that the arbitrator ultimately gets to decide the way the case gets presented as long as it's fair. You come down to that. I'm afraid and concerned that a lot of institutions don't empower the arbitrator with that ability to be able to deal with, in a real way, parties with greater resources trying to take advantage of parties without, or delaying what really can be a payment of money issue, right? Time value of money, put it off as long as I can and see if I can wear them down or otherwise take advantage. So that's my only contribution to that, but video offers a lot for us on that.
Brilliant, Jeff. Thanks for that. I think it's a great point, and actually it segues quite nicely. Nicola was there, and I'm now going to mute you, Jeff, and I'm going to bring in Nicola, who no doubt that segues very nicely into what she has to contribute. Nicola, I think you have to accept the unmute request. There we go. So we should now be able to hear you.
Hello, can everyone hear me?
Yes, perfect.
Okay. Hi everyone. My name is Nicola McCalliog. I'm a forensic, clinical and sports psychologist. So throughout COVID-19 so far, I've been supporting a lot of players and coaches throughout the process in dealing with the current circumstances. And just leading into what was being discussed, I felt it was important to obviously raise from a mental health perspective and the links to self-isolation, how this could potentially be impacting on all parties involved in hearings moving forward. A lot of the players and coaches that I've been speaking to understandably are struggling. This isn't a normal scenario. It's a very different environment that we're all now in. And I think that for some of them, they're using it in a positive way to spend more time with family. But for others, they're really struggling, especially ones that their whole identity is around who they are as an athlete, as a performer. And I think that when this comes into the situation, it's almost like a pressure cooker for them. There can be a lot of anger, a lot of frustrations on one side of the continuum, whereas on the other side of the continuum, it can lead to self-isolation and depression for parties involved. And I just think it's something that we all should be very aware of. And prior to proceedings, linking in how we can best support the people involved, but also how their voice can be heard when sometimes they may struggle especially in a video hearing. It could be something that might be quite comfortable for some of them to be at home, but for others, in the first time in a hearing, it could be quite confronting, and not really knowing how to conduct themselves within that, not having that support in the room with them, could be very challenging for them. So yeah, I just thought it was important to kind of raise those issues to everyone. So thank you.
Well, thank you very much for raising that. I think everyone would agree that's a very important issue that you've raised, and no doubt Murray will, flagged it that it's something you could contribute to the working group on, because, even just dealing with like esteemed colleagues in the sector, we do conferences, and some of the best lawyers in the world get nervous doing video conference calls. So it's a really good. And so if we could have your contribution to the working group, I think that would be, some guidelines and practical tips. I'm sure that would be extremely welcome in terms of how people could deal with that. Thank you for your contribution. Now moving over to Roberto, to bring in from dialing in from Brazil, to bring in your perspective.
Hi everyone, my name is Roberto. I am currently the head of research of the Brazilian National Dispute Resolution Chamber within the Soccer Federation. And I'm gonna go in a different path, I guess, in the sense of how we have been doing for the past 4 years, a whole digital reformulation of the whole NDRC there. Basically, we have been going through a whole side of education in the sense of how to help out parties on understanding the barriers that they face when it comes to technology and technology adoption during these resolution procedures. And it's been quite interesting because the barriers that we have been facing are basically the same that Mauro Capelletti and Garth Bryant have said in the past 50 years on access to justice. And it only comes a little bit tougher when it comes during those tough times of COVID. So first things first is basically the procedure that we have been doing for the past 4 years, and we haven't changed as much as it wasn't that necessary right now during the COVID time. First things first, we actually do the service of the new procedures. So there's no issue of a party needing to go anywhere to do the serving. And that is easier because we have the help of basically every single federation within Brazil, so the regional federations and the clubs. Aside that, when we do a hearing, we also have to double check when it comes to technology issues or technology barriers within the different regions of Brazil. Some regions have a tougher access to internet, for instance. And we do that during the hearing that we have when we are signing the terms of reference. And that's the most important meeting that we have, because it's when we can educate and help out parties with any technological issue that they have. And then we actually proceed to the hearing, and then we have the athletes or the coaches, and it hasn't gotten any messier than it used to be when we didn't have COVID. But it's really interesting to notice that we are able to do it even with athletes that are like in Belarus, and we had hearings during COVID, and they were actually pretty fine when dealing with the conference, with dealing with the hearing, as long as everybody was calm and supportive. So it's kind of a state of mind that also the panel has to be in trying to help out everyone in the meeting, everyone in the hearing. So aside that, I'd say that the most important things that we have done bureaucratically speaking is the work of the secretariat that we have. And first things first is the storage. We have storage, digital storage that is available to everybody, and everybody has its own password for their own proceedings, and it helps out smoothing things. Because right now, I'd say that the main issue would be, oh, how do I get access to any documents that I have for the hearing? And we can actually say, it's in the internet, it's pretty easy. If you cannot download it, please let us know, we can try to help you out. Also, the messaging, this back and forth is the main thing when it comes to the secretariat. We do the reaching out. So for instance, when we issued our guidelines in the beginning of the COVID confinement in Brazil, we are yet to have a lockdown, if ever. And it was pretty interesting. The parties were saying, yeah, you can actually go on with the procedures, we have everything we need, but please don't service any other case, because we are actually, most clubs are going through following period. Murray helped me out with this word yesterday. And it's pretty interesting because they were actually saying, we can do the work that we already have, but we cannot do any new work because we are not going to be able to access the documents. They are not yet digital in the clubs, in the intermediate, in the agents' offices, and so on. But the main thing was trying to maintain the workflow in a way that was helpful to everybody. And they were actually saying, please don't stop whatever you're doing, because we need to keep it going. If we don't keep it going, we are going to have a real issue later on. And at first, it was tough for me to understand what they were actually saying when they mentioned that. And nowadays, I'd say it's pretty much an idea of a show of faith, in the sense that we need to kind of move forward at least a little bit more. And well, I have probably 20 seconds, so I'm going to close saying that the idea that we had, and I'm actually really thankful to Maureen Wesson that is here. She's the one who taught me that when I was in the US, is the idea of conflict management and crisis prevention, and how we transpose this idea to the procedure within the NDRCs. And that's basically it.
Thank you very much, Roberto. So the point of advancement of technology, I think, and getting everyone up to speed and not assuming everyone has access is a really good point. We've had a question from Aman Chowdhury. It says, in recent times of COVID-19, there is a rise in amendments and changes to guidelines and regulations related. Can you all read that? And laws and contracts. You can read it. Would anyone like to take it? So basically, he says, my question is that due to these amendments to regulations, is there going to be an increase in sports disputes? As all the regulations are basically being updated, are we going to see more dispute resolution, and what steps can be taken? So rather than, who wants to take that? Roberto? Yep.
I can say what I have seen here. We have experienced a really huge raise in litigation within the NJRC. Although we're not doing serving of new cases, we received about, I don't know, probably 25 new cases in less than a month, which actually in 2 weeks, which was unbelievable for us because we usually receive 20, 25 in a month or so.
Right. So okay. Right. So the other point was John Merdzad and Nicola. I'm not sure if you're happy to come back to this, but John Merdzad raised a question in the last one that I'd overlooked, which I'd like to come back to you on. I'm going to unmute your mic now, if that's okay with you. And it was John said, in terms of adjusting to prior to and during proceedings, what would Nicola suggest? Regular breaks, shortened days, etc. So do you have any advice on that, Nicola, in terms of psychological welfare and well-being?
Hello, can everyone hear me?
Yeah, we can hear you, yeah.
Okay, sorry, I wasn't sure if you could hear me or not. Yeah, so what it's about is the preparation side is key to supporting from a mental health perspective. It's about kind of that preparation, that understanding. It's making sure everything's really clear so the person knows exactly what to expect moving forward. So as for a meeting, we have an agenda, it's just exactly the same principle. So there's no surprises for that person. So it puts them at ease prior. So everybody knows this is the plan of action moving forward. There should also be something where they know if they are struggling or they're in need of a break, they have a specific protocol to help them and support them through that if they need that time, because it might be becoming confronting for them within proceedings. I think that also that support system needs to be maintained after proceedings too. Okay. Because especially if the person feels that they've not said what they needed to say within the hearing, or they struggled with the outcome of that hearing, it's about having that continued support throughout.
Thank you. I wonder if video education in terms of what to expect would be useful, because for most people and for athletes, I know that Jen Gordon-Thompson has mentioned this point, particularly for athletes, it's an uncommon environment. It's very common for us, but it's uncommon for them. Maybe there's something that the priming that would make people ready, like there's very clear and well thought out, so they knew what the standard was to expect. Because I know also internationally there's a real divergence in let's say how the rules are applied and enforced internationally. Would that be something that you think would be useful?
Yeah, I also think that having it very relevant, specific to each sport as well, and the proceedings and different governing bodies, and having it as a case study, so it's very understandable, it's simple and specific, so that the person can follow it too.
Maybe there's something to take away there. Thanks, Nicola. Despina, over to you.
Hello. Hello, everyone. Thanks to Sean for the invitation. Thanks to Mari for this initiative. Wonderful to be in this virtual room with all of you today. So many prominent attendees. I saw many CAS arbitrators are here, dear colleagues from all over the world. Well, unsurprisingly, I agree with most of the comments from the previous speakers. It's in fact very difficult not to repeat the things that were said, since it all comes down to fairness and due process. I don't believe that the problems we're facing in ADR right now are COVID problems, because ADR is a method, and as a method does not and cannot deal with these substantive legal issues. Due process will always be the single overarching principle, even in times when the essential structures of the ADR system need to be remodeled very, very quickly, as it's now the case. I'm personally not fully convinced that we should go as far as creating strict guidelines at this stage. Rather, we need to let ourselves gain experience and learn from the use of different methods, different technological developments. I do believe that when it comes to the organization of an online hearing, the responsibility will shift towards the arbitral institution. And I think that was what Jeff was suggesting. And what do I mean by that? I'm merely speaking based on my own experience arguing before the CAS or being an arbitrator with sport resolutions. While SportRes has been organizing online hearings for years now, this is not the case with CAS. Thus far, the CAS approach has been that hearings must take place in person. The CAS sends letters to the parties reminding them that by opting for an online hearing, they bear the responsibility if something goes wrong. I don't believe that this should remain the case. The use of remote hearings should become so to say, institutionalized and embedded in the rules of any modern tribunal. I saw that Jeff suggested some other things that I couldn't agree more with him. So it should be for the tribunal, not for the parties, to offer the guarantees of a secure software for the hearing, avoid any confidentiality leaks. The tribunal should also offer a secure platform to upload requested documents. On the documents production issue, I think that the use of electronic hearing bundle is a very good initiative. It should be institutionalized, even though it's a predominantly common law concept. However, this should be done in a consistent way at an early stage of the proceedings, not just 5 days before the hearing. Ideally, the case managers of the tribunal, be it CAS or sport resolutions or a national tribunal, they should offer templates or specific instructions as to how to prepare this documentation necessary for the hearing in one electronic file, or even take the responsibility of bringing the bundle together. More than ever before, the panel should offer concrete directions with respect to the hearing, ideally offer a preliminary meeting, as many of the other speakers suggested earlier, in order to delimit the issues at stake. I recently had a very positive experience of a test hearing where the entire panel participated, not only the parties, and the chairman asked several questions with respect to the hearing schedule, use of interpreters, questioning of witnesses, tried to get both parties familiar with the software and the procedure. Well, my first reaction was, well, I don't need that. I have some online hearings. I had some online hearings before. But then I realized that it is actually essential to bring all parties together beforehand. And this is essential in order to compensate for the lack of in-person contact, which is crucial in in-person hearings. On a more substantive level, I do believe that the use of conciliation is an excellent tool, because unlike mediation and the CAS rules, for example, it is a different ADR mechanism. Conciliation is embedded in the CAS rules. It's embedded in the sport res arbitration rules. And actually the arbitrators should make more use of that tool. Overall, I'm confident that this period is, of course, very, very tough, but it represents a very steep learning curve for all of us. And in the end, we'll discover different methods, software, rules that will ensure both fairness and efficiency at every level.
Thank you, Despina. You're within the you've shaved off. We saved a minute there. That's brilliant, and then the contribution was no less valuable. So thank you. Very insightful. So thanks for that contribution. I'm not sure if we have any specific points any of the panelists would like to, other members would like to comment on. I know that we've got a question from Liz. Liz, I'm going to allow you to talk. If you don't want to talk, then we can just read your question. But it'd be great to hear your voice, Liz Riley. You've got a question.
Thanks, John. Can you hear me okay?
Yes, we can.
Great. So yeah, I was just interested on a very practical level if anybody had any experience, either good or bad, of how to deal with interpreters during remote hearings. Particularly in the context, not where it's an interpreter for a witness, but for actually for one of the parties. And I mainly ask because, I mean, so remote hearings are actually for the IPC, we do remote hearings all the time for cost reasons. So it's not really a COVID specific question. But I'm just interested because I had one particularly bad experience more recently where the panel allowed or required the interpreter to translate everything sort of sentence by sentence. So what was supposed to be a 3-hour hearing turned into sort of a 2-day insanely lengthy hearing. And I was very conscious that it was certainly not a good example of how to deal with it. But at the same time, we didn't really have any particular procedures in place. Our arbitrators were all volunteers as well. So to be honest, I suspect it was something that the particular chair hadn't come across before either. And then it was too late to stop things once we got started.
I think it's a very good question. So Despina, do you want to take that? I think Jeff might want to contribute as well.
Yeah. Okay. So I had experience with a recent hearing where the panel had to deal with that request from a party. And so the panel essentially said that to the extent that your opening and your closing statements can be prepared in advance, then you can give all these statements to the interpreter beforehand so that they can ensure that this will not last longer than that. So they only granted a short additional time for the pleadings of that party that necessitated interpreters. I don't know if that helps.
Thank you, Despina. Murray, you wanted to add something?
Yeah, this really comes back to some of the points we've already touched on to do with procedure, flexibility, rigidity, giving responsibility to the tribunals. You've got to have a really expert interpreter, and the extent to which they have to interpret for parties has to be considered and discussed early on in the case. I've had proceedings, for example, where the interpreter has been typing what's happening for the party, probably not giving every word in translation, but just providing summaries so that the party understands things. On other occasions, you have a fantastic interpreter who is almost interpreting simultaneously, and you lose no time whatsoever. The trouble is, people don't really consult about it. Parties are left to provide their own interpreters. There isn't a discussion early on with the tribunal as to exactly what's involved, and that's why you get the occasional disaster.
Could it be something, sorry, I've been having conversations from a LawInSport perspective because of our international membership on this issue of a translation in terms of the written translation, but also, funny enough, on some of the video conferencing that we're doing, having real-time translation. Is there a job here to sort of make recommendations or a recommended list of translation companies who perform better? That would be particularly useful, again, because the opaqueness of the market is where would you go? Because I know that from athletes' perspective, it's been a huge issue. Where do you go if you're not used to doing legal translation? Where would you go? Good, I have searched for online, and I went to individual experts for their advice as opposed to relying on the search results that I received, because they said just because someone calls themselves a legal translator doesn't mean they're actually fit for purpose. Despina, did you want to comment on that? I know Jeff's got a particular question for you as well.
Yes, because I think that brings us back to a non-COVID related topic, which is the Sun Yang case. What happened in that case was that the translation was a disaster, and then people went on to say that it should be the tribunal's responsibility to ensure a proper translation. And then there are different opinions as to that, because a tribunal as such should not advertise the work of specific individuals. It should be the responsibility of the parties to make sure that the translation services that they are using are efficient and of good quality. So I'm a little bit divided on that as to whose responsibility it should be.
If you have an open list of arbitrators, why can't you not have the same standards for translation? Like, as in have some standards. It seems there's no standards at the moment. Why can we not create some standards given the expertise? Anyway, just a thought. Jeff, over to you. I know you've got a question specifically on the point that's been raised. Sorry, go on, Jeff.
Sorry. Okay. So I won't jump into what Sean just raised. I see a thicket of issues with certifying qualified translators and arbitrators by institutions across the world's languages. But having said that, I had a case recently where the remote translation was better than any the remote interpretation was better than any live interpretation I had. The parties had figured out how to work with Zoom to create a separate audio channel for the language of the proceedings and the language of the witnesses. And the interpreters engaged in simultaneous translation in Mandarin, and it was beautiful. It was a thing to behold. It was beautiful. That is the exception, obviously. But there are mechanisms now with software to allow you to get a qualified interpreter anywhere in the world now to sit in a virtual room somewhere and do this in a simultaneous way. There are challenges, including lag and the internet and a variety of other things. But I was in shock at how beautifully and easy this went. I was expecting a complete shit show, as we would say, and it isn't. I'll say on the issue of qualification of interpreters, in the United States legal system, we have state qualifications to do court interpretation that covers almost every language you could think of, and there's a limited number of these people, and they're highly sought after, and they're paid lawyer rates to do it, and they do a good job usually. Not every system has that concept, I get it, and I don't know if sport arbitration is advanced enough to get to that point, but something has to be done outside of COVID with the translation interpretation issue, and I think the Sun Yang case showed that. I mean, it was ridiculous what went on there, so.
So thanks, Jeff. I think the wider point is here, if it's COVID has just created an environment in which everything's accelerated across sport because we're doing research in various different areas. So, we've been using tech like this for 10 years, and it's taken 10 years for the legal, in a COVID situation, for the legal sector to adopt it. We've been doing video calls for 10 years. I was just shocked how slow it is. So best practice is best practice in good times and bad times. And I think that that's what we're hoping to achieve with this group, is to encourage best practice. So thanks for that contribution. Next up, we have, on this point of best practice and some guidelines, we have Stephen. Now, I'm meant to be sharing your document, so let me bring that up. If you want to start, Stephen, I'll bring up your document as you're talking.
Thank you. Good afternoon, everybody. I'm Stephen Flynn. I'm a barrister at King's Chambers, specialising in sports law. One of the issues that's come up from the discussion paper has been a potential appetite towards developing some guidelines, and even within the working group there has been a debate as to whether this is something we should enter into and something that would assist or would it cause more difficulties. But to further debate, I have pulled together a first draft of potential guidelines to be considered, to see what the feedback from the wider community is. These are very much based on experiences that I've had of things that have worked and haven't worked over the last 6 to 7 weeks during the COVID period. I should emphasize that they're intended to be guidelines only. They're not going to be incorporated or supersede any rules or procedures that govern the disciplinary hearing or arbitration that you're dealing with. There's some issues to consider. There are 25 of them. I think time won't allow me to go through each of them, but just to highlight some of the thoughts that I had. Given the position we are in relation to COVID, the presumption for number 1 and 2 would be that all final hearings and substantive interim applications would be conducted via video conferencing, and only where it is demonstrably not possible would these be dealt with via telephone. The reason being that the view is that video conferencing is preferable. It allows for better interaction between the tribunal and the parties, and some issues that have already been raised today about, and Jeff was talking about assessing witnesses. Whilst 360-degree cameras aren't necessary, the ability to observe a witness is of assistance. Slightly different with case management, where matters could be dealt with via video conferencing or telephone, but that could be agreed between the parties and the tribunal. Number 4 there, I don't know, Sean, if you could scroll down a little bit. This is in terms of a situation where it's not felt by one party possible or in the interest of justice for the matter to be dealt with and conducted in person. If that is the case, then an application to be made to the tribunal, supported by evidence, considering why it is considered necessary. Also practical issues as to what is the likely timescale of delay if it is going to be dealt with in person. And over the page, Sean, if you wouldn't mind. At the top of that page, what arrangements are proposed to ensure the safety of those attending such a hearing? That's very specific to the COVID period we're in. I appreciate that it may be something for the tribunal to actually determine, but when an arbitrator or a disciplinary panel has to consider that matter, they're not going to do so in a vacuum. They're going to have to take some consideration as to whether this is going to be possible and whether, for instance, a room could be made available with everybody being 2 meters apart and with safe systems in place. So we'd expect, well, I would suggest that parties should provide that information. In terms of the actual preparation for the hearing, I think this is probably the most significant part as to getting everybody aligned, and what Svina was saying about bundles and things like that. Documents should only be necessary in the bundle rather than a shoving everything in kind of approach. And number 7 there, these should be approved by the advocates, because they're the people who are going to know which documents are likely to be referred to. Electronic bundles becoming the presumption in these type of hearings, and I've suggested that PDF format would be the appropriate format. And I appreciate there are a number of areas too. It may be suggested that it should just be any accessible format, but certainly in my experience, PDF has been the most widely used and accessible without the need to download additional programs. If you want to go across, Sean, as you appear to be doing, hyperlinks in the index to the bundle have been proven useful, but certainly number 12 there, some form of way of bookmarking and navigating methods. Number 14, one of the things I suggest is that it should be provided to witnesses, certainly from an advocate's perspective. There's nothing more frustrating than wanting to cross-examine or challenge a witness on reference to a document, and it turns out that they haven't got it in front of them. Similarly, in relation to 15, video or audio recordings being available locally, while screen sharing works very well if everybody's got the bandwidth to accommodate it, If you are in a disciplinary hearing and it's an on-field matter or something like that, being able to view it with certainty is an important aspect of getting hearings done and not lengthening them unnecessarily. Sean, if you want to move on to the last one, I appreciate I'm up to 5 minutes now. In terms of the hearing, 19, a reference to them being formal hearings and people being reminded of that. Practical experience based on people raising their hands and highlighting if they can't hear, if there's any difficulty in relation to that. 24, I think, is one of the most important, which is to remind witnesses that the evidence should be given is their own, potentially identifying anybody who's in the room with them, and for parties not to contact witnesses. It's become quite common now for people to have separate WhatsApp groups whilst in a video hearing, so to be able to communicate, but they shouldn't be influencing a witness's evidence. Interpretation, heard a lot about. What I proposed was parties to arrange and consecutive interpretation, though having heard others, these are all things that are open to discussion and potential argument, but that I thought was a framework with which we could build around going forward. Okay.
Yeah, thank you very much. Now I know Jeff's got some. I knew that he'd be very engaged in this in the discussion. He's got some more points on translation. Jeff, whilst we wait, I'm just going to go through to see if there's any other questions on the points that Stephen's raised. This point of sharing best practice and having some guidelines, even if it's not perfect, I think seems very sensible to me. I've got Massimo who also wants to put his hand up. So we'll go to Jeff. I'm going to go to Massimo just because we've heard a lot from you already. As much as I love hearing your voice, it'd be great to get Massimo's contribution. Then we'll come back to you. Massimo, you should have your.
Yes, Sean, can you hear me?
Yes, perfectly.
Yes. Now, just very short remark to tell you, all of you, that I don't know if you are aware, the Spanish Arbitration Club, the Club Español de Arbitraje, has drafted and issued a code of best practices in arbitration last year that now is being translated in several languages. And right now we have started a working group on a code of best practices in sports arbitration. The only problem is that it is in Spanish. So we are working in Spanish, but anybody who is proficient in Spanish is welcome to join, and maybe we can find a way of coordinating, or at least consulting with the other, your working group, because I think there is a mutual interest in sharing experiences. It's less detailed. It goes less to the idea of really explaining how any hearing should be handled. It's a more general approach, how institutions should deal with issues, how arbitrators, how advocates, etc., etc. They're all different positions in arbitration, what the best practices are. And we already found that several things are different than commercial arbitration. So we are just started working. That's it.
Perfect. Thank you, Mr. I think, not speaking on behalf of everyone else can contribute, but this is done with the spirit, and me and Murray have discussed this at length. I know the others are, I think, correct me if I'm wrong though, but we're all in the spirit of collaboration. And I think this opportunity for us all globally to work more collaboratively together, and rather than be, the individual groups work in isolation, is something that I think everyone's willing to embrace. So we would absolutely love to take you up on that. Well, in LawInSport, we're working with as you know, with Michele Colucci as well, with the Sports Law and Policy Centre on various different things, going to try and get them involved as well. So I think the more we can do that and work out an effective way to come together, I think makes a lot of sense, because we'll get a better outcome from everyone. So thank you for that contribution. Jeff, I'll come to you and then we'll go straight over to Chris. Thanks, Massi. Oh, sorry, Jeff. You're so eager to do it. You unmute yourself before I get a chance.
No, I didn't have anything new to add. I put some observations in the general chat area, but I don't have anything special to add. I had asked the question earlier that Despina ran out of time on, but about whether the new CAS council and others like in that position need to now become IT specialists, but that's a separate discussion. I think the only thing for me on this, my observation in the chat, was that the guidelines you have to be careful with, because you're never going to convince an arbitrator like me to do all of these things, right? I'm going to do my thing. I'm going to issue my order. My order will include a lot of these things, because I already do, and you've got some new ideas in there that are pretty good. So how this would get communicated without creating an additional standard that creates an issue would be, something I'd be concerned about. But at the same time, I think it does a good job of alerting counsel to what they need to prepare for, and also arbitrators about what they need to be concerned about to manage this, because the arbitrations online are tough. They take a lot of coordination and management. You need a managerial arbitrator. It's not like before where everybody just shows up and does the usual thing. There's a lot of advanced coordination needed, and it needs to be known in your orders.
Very specific skill sets. Thanks, Jeff. There is, one thing, point of reference, and I know that John Dyson, Lord Dyson, contributed some comments on this, but obviously the Judicial College provides guidelines, right, that people can use, and along those lines, why can't we do something like that? Anyway, just a thought. Kwadjo Ajipong, you've asked a question. I'm going to turn your mic on now if you're happy to talk.
Hello everyone. The question related to Stephen's guidelines, which are very helpful. Inevitably, video technology will break down during a hearing. Would he propose in that situation that we wouldn't revert to a voice conference call and would rather seek an adjournment in those circumstances?
Great question. Thank you. Stephen.
I think it must depend on what's in the interest of justice. That must be the primary goal we're all looking at. If it's something that can be dealt with via telephone without impinging upon that, then yes, I think it would be ridiculous to seek an adjournment and the additional costs. But if it is going to result in some unfairness, then I think it has to be considered by the arbitrator. And going back to what Jeff was saying, it will need arbitrators to manage these processes and understand them and take it on a case-by-case basis. The guidelines were not intended to be prescriptive and give rise to any remedy if you didn't follow them. They were just something to bear in mind when you were trying to manage the process through to an effective hearing.
I know that Roberto has had a couple of telephone hearings. Roberto, I don't know if you saw in the chat. Do you just want to comment on that? And then we'll come to Chirato Banerjee. I'll put your mic on shortly. But Roberto, do you just want to comment on the telephone hearings and what your approach was?
Yeah, for us, we have had a couple of experiences with telephone hearing. It's the basic rule that we have used is if the parties both agree, then it's okay to have a telephone hearing, but it's highly unideal, if there's a word for that, for the panel, especially later on, because we record the hearings and then we have it for later stages. And the sound of the telephone hearing, I'm gonna use a word like Jeff, so sucks.
So it's not very good. Okay, so it's got its own limitations in itself. Okay, great. Chirato Banerjee, and I hope I'm saying that correctly. I'll turn your microphone on now. Would you like to ask your question? Hopefully.
Yeah, can you hear me?
Yes, perfectly. Thank you.
Yeah, thank you, Sean. Thank you, Stephen, for your excellent guidelines. Well, I just one question regarding the digital signature aspect regarding the documents that we might have on the e-bundle part. So like if a new document is introduced or where a party needs to produce some affidavits, what are the, I know it's a bit on the technological side, but then what are the requirements for an e-signature maybe at some point of time during the hearing? Like probably where a party might be given a screen to sign it. So what do you think about that? Like when there are some intermediate documents required at any point of the hearing?
Thank you. Stephen, did you want to take that from your experience, or Murray?
I think that would be on a country-by-country jurisdictional issue, wouldn't it? In the UK, a digital signature is satisfactory for affirming a statement of truth. So I think it would be very difficult for us to impose anything that would be contrary to a jurisdiction's provision. So certainly in the UK, a digital signature is satisfactory, even if it's just typed out, as long as it's confirmed by a statement of truth.
Thank you, Stephen. Right, moving along, we've got one more question, and then Chris will still have 15 minutes, so we'll have plenty of time. I know Murray wants to wrap up, so we'll just do a very quick question from Kachi Okizi. Sorry, apologies for that. If I can find you on the list, and I'll allow you to talk now. Would you like to ask your question? Hopefully it works. Maybe, is it working? Can you hear us, or can you speak? If not, I'll unmute you and just read out the question. I'll give you a few more seconds to try and get it sorted. If not, I'll start asking the question. If it comes on, you can ask it. So it says, sports lawyer from Abuja in Nigeria. Good afternoon all. I'm part of a team tasked at recommending a suitable model for national sports dispute resolution entity in Nigeria. What would the panelists recommend by way of future-facing model, taking into account lessons from current experiences? Who wants to take that? It's quite a broad question, but if there's, so is someone setting up a national dispute resolution body for sport? Obviously, Australia are currently doing it at the moment. Have done it, sorry. So they're probably the latest ones. There's a FIFA doing a whole bunch of different ones, and then people use Singapore, I believe. Murray, we were talking about this in terms of as someone who had a future-proofed model. Graham, if you just, I'll unmute you if you.
Excellent. Thanks, Sean. I was just going to make one very broad point in response to that, which is this. If it is a national sports dispute resolution centre, a good starting point is to look at those jurisdictions that have a similar system of law in place. There is often a real tension between those with a civil law code and those with a common law code, with perhaps not distrust, but certainly uncertainty from one looking at the other. So an excellent starting point, I think, would be to look at those jurisdictions with a system of law that's a parallel to or akin to that in place in Nigeria.
I think that's great advice. I know that obviously in Japan and other places around the world, they've been doing similar things, going out doing research projects and seeing what's suitable for the limitations and national laws. Kendra, so you would like to say something, and I'm conscious, don't want to rush Chris. So over to you.
Yeah, it was just to say, in terms of setting up a national body, I think one of the key things, I mean, you've obviously got all of your procedures and processes, but it's the pool of arbitrators, which is to make sure that they're properly representative and independent, effectively to give any new body effectively the confidence of the market. Yeah.
Absolutely. And if you need any help with introductions, we can try and point you at least into the right direction, if not introductions anyway with that. So I'd be more than happy to help on a non-commercial basis, obviously, just on a pro bono, just to do some introductions. Chris, thank you for being patient and waiting your turn. Over to you to do the last presentation before we take just an open questions and hand over to Murray to close.
Thanks very much, Sean. Hello, everybody. My name is Chris Stoner. I'm a barrister based in London, practicing from Cell Court, undertaking, amongst other things, sports disputes for more years than I can wish to remember. I'm going to just say a few things on the actual conduct of the hearing, which covers a number of smaller points, which I couldn't begin to cover inside 5 minutes, but I just want to concentrate on a few principal thoughts that I've had. And they must all be in the context that the two overriding aims or goals, I suppose, of the conduct of a remote hearing, whether that be by video or on the telephone, must be, firstly, as far as possible, to emulate the substantive element of a physical hearing, by which I mean that there's a proper and robust exchange of submissions and proper cross-examination where that's required and expert evidence admitted. And secondly, that everybody should be seeking to ensure that the hearing meets the necessary requirements of fairness and equality. And I think key words, particularly in this current crisis and as remote hearings develop, are flexibility and cooperation. And by cooperation, I mean between the parties in the run-up to the hearing, including consultation on the proper functioning of the hearing, and cooperation between the parties and the tribunal itself, probably being led by the tribunal in terms of ensuring a fair hearing. Now, the first point I want to make is what I've called the preliminary session. It's been touched upon this afternoon by one or two people, and I strongly advocate that all participants should have a trial run to ensure that everybody is familiar with the technology before the hearing actually starts, especially given that there will inevitably be differing proficiencies in the particular platform that is being used, and also to ensure that any compatibility issues are ironed out. Whatever the semantics that are used, whether it be a preliminary hearing, a test hearing, a stage 1 hearing, I myself wonder if it's an opportunity to actually enshrine in the norm that when a remote hearing is fixed, that a time is fixed in the day before or 2 days before for some form of shorter session to test everything out. But also that can be used not simply to test the technology and make it sure that everybody is compatible. It can be used to cover those housekeeping matters that otherwise take time at the beginning of the hearing, such as going through the speaking protocol, ensuring everybody can use their e-bundles, and everybody's e-bundles are the same. They should be. I have heard 1 or 2 instances in the past weeks where people's pages are not quite the same. Running through matters such as timing as well. And not only will that hopefully save time at the beginning of the hearing, it might also settle the athletes, by which I mean obviously sports people, into the process that they are going to see in the following couple of days. Another point that has been mentioned that I think is necessary in relation to to raise in relation to the conduct is confidentiality. Confidentiality, obviously, in a physical hearing is often a closed door with a sign on saying "do not enter" or something equivalent. We all know that it may be impossible to have absolute confidentiality online, but a number of steps can be taken to provide essential confidentiality, such as providing parties with individual passwords to access the hearing, to have facilities such as manned waiting rooms before people can access the hearing. And I think when it comes to witnesses and matters of that sort, the tribunal, if they can, within the framework of the rules they have, should make it plain that if individual participants, including witnesses, breach the confidentiality requirements that they've put in place, which hopefully would have been sorted out prior to the hearing, then that in itself is a matter that might be sanctioned. A couple of other points that have been touched upon. I think it's essential for the proper conduct of the hearing for there to be private communication, whether that be during the course of the hearing, whether that be between the tribunal members, between counsel and their solicitor. I saw a comment from Jeff earlier to remember that WhatsApp doesn't work in China. Fair enough. There are a number of different means that can be used. WhatsApp is a common one that's been used in hearings I've been involved in. But there has to be some form of process for private communication to replace those virtual whispered comments, or to be the virtual equivalent of the whispered comments or the post-it note. Another point for the smooth conduct of the hearing, I would suggest, is that there should be a clear designated person, so that if anybody drops off the hearing or is having difficulties, there is someone that's been identified beforehand that person or everybody can contact, because sometimes, particularly with multiple participants, if someone drops off, they can drop off screen. So that's another point.
Sorry to interrupt you, Chris.
Time.
Yeah, yep.
and just 2 very quick points, and if I may, Sean, I think there should be a speaking protocol sorted out. That'll be a matter for the tribunal chair. That can deal with not only the issue of how the timetable is to be set, but also how people are to be interrupted, rather than there being crossing references, etc., etc. And very quickly, the final point, somewhat ironic perhaps, but that of timing. Anecdotal evidence suggests that remote hearings are more tiring, and that may have to be taken into account in the construction of the day. And I think also sensitivities will have to be had by tribunals to participants' difficulties, particularly in the current crisis. If someone has to go off and collect their child at school at 3 o'clock and there is no other childcare facility available. So there are some thoughts. There's a whole host of things to debate in relation to the actual conduct of the hearing.
Thank you very much. Just from a practical perspective, we've got our conference we're running, and we've split it for that exact reason. We split it over a 2-week period because it would be too exhausting for everyone to do in a day. That seems common sense approach. So thank you for that. I can see Murray glaring at me. Feels that way. Maybe you're not. Maybe you're just staring at the screen. But I know you're a stickler for timekeeping. We've got 5 minutes left. Would you like to? We haven't got any further questions as far as I can see. So if you have, please, put your hand up now. If not, I'm just going to hand over to Murray. Murray, over to you. You can do the summation, and we can close off the call on time.
Right, thanks very much, Sean. Well, thank you very much, everyone who's participated, speakers and others. This project, I hope, is gathering momentum. We started off as about 6. Today, I think we've had nearly 60. And as far as I'm concerned, everyone has something to contribute, and we will only make progress and prove that this effort is worthwhile if we can keep on with that momentum and continue to collaborate. The trouble with all these different institutional rules, and I may as well be quite frank about this, is that there are rivalries. There are all sorts of different institutions and all different sorts of countries, and there doesn't seem to be out there any one particular group that is going to try and collaborate in the way I hope that we are able to. So I would urge everyone, not only the people who have been able to attend, but also those who have emailed in and who will be trying to involve more, but who couldn't attend. I would urge everyone to put collaboration first and to see what we can get out of this process. It's not going to dictate anything to anyone. We're just going to try and encapsulate what we as a group think is best practice. We're going to try and put together some ideas. We won't be able to please everyone. There will be lots of experts and non-experts who will want to do it a different way for whatever reason. So going forward, the plan is that everyone who wants to continue will, through Sean and myself, continue to make comments. Please give your permission to be part of an email group so that we can satisfy GDPR and other considerations. Where you come across something, please let us know. I'm very happy to filter in things, but of course there is a lot of work to do. Sean has got his team of researchers, but no doubt they're working on 100 other things at the same time. So what is actually needed is some work to analyze things, to look at different guidelines, different experiences. Nick DeMarco, thank you much for what you've done already to analyze and absorb and chart out and summarize some of the work we've already done. But we do need more. This isn't going to fall on one person. It's got to be a collective effort. So again, thanks everyone very much. I've learned a huge amount in a very short period of time, and I think that the format has shown, if we needed it to be shown, how the technology can really help us. Some of us want this to stay, not as regards all the background to it, but we are learning so much about justice and about how to resolve disputes during this time of very heavy stress. But please, let's all remember, social isolation is not good for the human soul, and we all need support and we all need contributions. And if we can do that collectively, then I am confident that we'll do something worthwhile. Sean, enormous thanks for hosting it so ably. If there's anything that you need to mention, either practical or otherwise, we've got a couple of minutes and it's all yours.
Oh, awesome. You regret saying that. I don't think it's the rough following the smooth with me finishing off. But just to thank you, Murray, for your efforts and everyone else involved. I mean, it's really something we're doing, as I mentioned, the Sports Law and Policy Centre. I strongly advise you check the guys out, the fantastic work they're doing there. There is such an area of collaboration. It's something that LawInSport has been trying to do for many years, and we've got many of the speakers on our editorial board or contributed to LawInSport. is something that's been deeply frustrating that it hasn't happened, but it seems that this moment in time is really bringing people together in a way that we can see the common objectives and benefits for working collaboratively. All of the information we'll host on LawInSport, and it'll be publicly available. You won't need to log in. So anything that comes from this will be publicly available. Do what you want with it. I think that's the general consensus for everyone in the group, because knowledge is power if we can share it. Other than that, yeah, if we can be supportive to people, we'll try to be, as I'm sure everyone else would be in the group. Just said it's been a pleasure and a real privilege to work with such great people anyway, and you know, on the group today. Thanks for everyone for participating, for asking your questions. The video, I think Murray, we said the video and transcript we're going to try to circulate as well and be freely available afterwards. So I think join me in a virtual round of applause. I don't like the screen high-fiving, so I do a virtual clap, but thank you to all the speakers for your contribution. Thanks, Nick. Yeah, other than that, have a great day wherever you are in the world, and thanks so much for tuning in. I hope you found it useful. If you did, please, again, as Murray said, please tell people about it and share it, and you know, get in contact with me and Murray. We'd love to work together with you. Thank you. Ciao, au revoir, etc.